Fordham.
My lords, my lady, can I start with who's here, or some of them? Mr. Eady, Patrick Goodall, QC, Simon Pritchard and David Lowe are all instructed by Alison Chubb and Anne Mihailovic of GLS. On the page, you have Paul Bowen, QC, Eric Metcalfe and Catherine Meredith at page 7091 for the Office of Children's Commissioner. They're instructed by Sarah Truman and Alison Kirby Harris of Freshfields. Now, also on the page, at page 7547, the Law Society, supported by the Bar Council, Diana Rose QC and Ian Steele, instructed by Therese Prince of the Law Society Legal Services. I'm here with Ben Jaffe, Naina Patel, Alison Pickup, instructed by John Halford of Bindmans for the Public Law Project, whose access to justice in this case was secured by cost protection. We're very grateful. We're also very grateful to you for the expedition that you've given. Parliamentary privilege has arisen. The position on that is this. The Court of Appeal dealt with it at page 10 of the bundle, paragraphs 19 and 20, and referred to a note that we had provided. That's paragraph 20. You now have that. I'm afraid to say, volume 12 of the authorities, at least it's not a lever arch file, it's a thin file that I think it might be on your desks.
Yes, I'm sorry. Yes, thank you.
And tab 132
Thank you.
is that note.
Right.
Mr. Bowen, whose permission was written only, has put in a note. You've got that at the next tab at 133. I'm not proposing to deal with it now, but we'll certainly take it in our stride.
Thank you. Now, there are two main issues which
Yes.
are referred to in generally and in law's judgment in the Court of Appeal as the ultra vires issue and the discrimination issue. I think the way we'd like to proceed, unless any rooted objection from you or Mr. Eady, is to hear you both on the ultra vires issue and then see where we've got to.
Thank you, Madam. I'm relieved I didn't plan to take discrimination first. A short introduction. The residence test for civil legal aid, paragraph 23 of the Statement of Facts and Issues summarises it, serves to exclude, you want the Statement of Facts and Issues and you're looking electronically, you're going to find that at page 6921, but it's in the core bundle, the core volume, obviously, for those who are working from paper. It excludes individuals who are impecunious, relevantly, who are meritorious, relevantly, and it excludes them from the legal help that legal aid will provide and the cost protection that legal aid provides. It does so in areas where the need for legal aid is pressing. That's a quote from the Court of Appeal, and you'll find that in paragraph 4 of the Statement of Facts and Issues on page 6915. 6915 in paragraph 4. So the areas of highest priority need for legal assistance, and it does so in areas where that priority need for legal assistance relates to rights that have been conferred on them under domestic law. In substance, the residence test will exclude recent migrants and irregular migrants. It's not exclusively a nationality or foreigner test, but that's the substance.
Recent migrants and
irregular migrants.
Irregular.
Those who don't have a regular migrant status. But if you look at the subject matter and think about the paradigm cases, and we've developed it all in an explanatory appendix, who will the people be that will fail? There will be some other categories. There could be, for example, a returning British citizen who's never been here for 12 months. And in the first 12 months, they wouldn't get legal aid. And there will be, you've got two individuals who are arrested overseas and put into a British military detention facility. While detained, The British citizen too wouldn't get legal aid. On return, they would. But in substance, and we can see the reasoning laid bare in the documents, it's irregular and recent migrants. Now, the Court of Appeal, my lords, my lady, at paragraph 22 of the judgment, and that's page 11.
Yep. Of Appendix 1, yep.
About 10 lines from the bottom of that page, doubted whether it could be humane or rational to further cut back on legal aid on grounds of need. For the subordinate legislator to draw distinctions on ground of need between the various legal services listed, children, vulnerable adults, human trafficking, homelessness, gang-related violence, would constitute an exercise whose rational and humane basis might well be hard to find. The pressing nature of the areas are witness to that fact, but there's limited scope, and you can see it in the way the power was described. We'll come back to that. So, doubtful whether you could further cut back humanely or rationally for everyone is the logic there. What does the residence test do? It cuts back in precisely those ways, but it cuts back in relation to a group who can't meet the test, notwithstanding their equal rights and their equal needs, and notwithstanding that the rights that they have, take welfare benefits as a good example. There is a category for welfare benefits and welfare benefits appeals in LASPO. Those are the benefits that have been specifically conferred on non-residents, irregular migrants or recent migrants, because otherwise you won't have the merits and you won't pass the merits test to be able to pursue your appeal. So the British taxpayer is already paying for the rights that they have deliberately been given, but what you can't have in these most pressing areas in a way that would otherwise be inhumane or irrational, you can't have legal aid to vindicate those rights. And that's why this case is accurately summarised, we say, by the Divisional Court at paragraph 2, when they say, and this is page 26, the effect is to exclude those who have a better than 50-50 chance of establishing a claim. The subject matter is judged to have been the highest priority need for legal assistance without the means, on the grounds they lack a sufficiently close connection with the country to whose laws they are subject. We say it's unlawful, and for the purposes of today, see where we go, it overreaches the relevant purpose. There is a power, a Henry VIII power, to redesign scope. There is no power to expand purpose of scope. That's what it comes to. Divisional Court, all three of them were right. It, in any event, would be ultra vires for what Lord Phillips called in the Ahmed case a closely linked reason, the principle of legality. But I don't shrink from that. The principle of legality does not permit you to discriminate. This is a context where the constitutional value of equal protection of law arises. Mr. Eadie powerfully makes the point, well, you can't say simply access to justice, because any redesign could have an effect on someone's access to justice. I agree. But what he misses is equal protection of the law. You can differentiate, and there is an express power to differentiate, but you cannot discriminate. You cannot take two people who are in the same position, same means, same merits, same rights, same need. And whether it was boys or girls at school with special needs, or whether it's people in the South and people in the Midlands, or whether it's foreigners or British, or whether it's residence test.
Isn't this the second question?
No, because the principle of legality doesn't get to stage 2 justification. The principle of legality is that you can't do it unless you've got an explicit statutory power. So it's ultra vires.
So, wait a minute. The point is relating to construing Henry VIII clauses or construing powers to make regulations general?
Both. It's not a Henry VIII point, the principle of legality point. No,
okay.
It's not. And I can test it by reference to liberty. It can be justifiable to remove someone's liberty, but the first question the common law will ask is the power explicit that you can interfere with liberty, because that's how important liberty is. Mr. Eadie says, no, this is an invisible point because the principle of legality only protects against an abrogation of rights, and that's my second ground. And on the principle of legality, if we get to it, on the principle of legality, I say that's wrong. And I say that's wrong by reference to authority in this court.
Yeah, I think that's the Ahmed and Lord
That's
Philip.
the Ahmed case. In the Ahmed case, it was specifically decided that there was no abrogation. But the statutory power did not permit the interference, and that was the basis on which that case was decided. Unjustifiable discrimination at common law, this is partial and unequal, and you can't have partial and unequal delegated legislation ever since Cruz and Johnson. Or by reference to the Human Rights Act, Article 14 with Article 6, but that's not for now. Where does it leave those who will fail the test? And the Divisional Court spelt this out by reference to some evidence at the top of page 42, paragraph 75. Obvious, they say, that absent legal assistance, litigants will be substantially hampered in vindicating their rights. It's in part accepted by government, who've acknowledged that if litigants choose to represent themselves, that could lead to an increased burden. That's the more litigants in person point. But that individuals may choose not to tackle the issue at all. And tackle means you have a meritorious claim by reference to a right and you cannot pursue it further because you haven't got the help that you need. Choose not to tackle. If you've got the core bundle and were to turn, please, in the core bundle to page 106, you'll see at 106 there is a paragraph 123. This is in the decision document on the residence test from September 2013. It starts on page 90, but by way of introduction, if you look at 106, paragraph 123,
Yes.
the government assessment in the second sentence, we do not accept there is likely to be a significant increase in the number of litigants in person. That's their assessment, so people aren't going to go it alone. These are categories of priority case that have already been assessed as cases where you can't expect people to self-help, they don't have alternative routes, and they don't have alternative sources of funding. And then at 198, page 198 in the same bundle, my lords and my lady will find, and this is as part of an impact assessment that starts at page 192.
Yep, paragraph.
Paragraph 25. If they choose to represent themselves, this could lead to an increased burden on the court service due to a rise in litigants in person. 26. However, it is equally possible that individuals may choose, that's the word, not to tackle, that's the word, the issue at all, leading to a reduced workload for the court service. That's what this means. That is what the implications of this are. And as we put it in our printed case at paragraph 2.10, so that's obviously in the core bundle, and my lords and my lady will find that at page 6955. We describe in paragraph 2.10, bottom of 6955, the consequences. We have a quotation at the bottom of that page, which is an extrajudicial comment, and we invite you to adopt that as a judicial finding. Because that's the implication. A rank denial of justice and a blot on the rule of law. So that's where it leaves them. Where does it leave the public authorities, the local authorities strapped for cash, who are supposed to do the special educational needs assessment for the child in the class who's the foreigner, with no regular migration statement, and the child in the class who is British? Where does it leave the unscrupulous landlord, who is supposed to take the urgent steps where there is the immediate risk to harm because of unsafe premises that people are renting? Where does it leave the police in pursuing the youngsters against whom effectively control orders are sought because of alleged gang-related violence? Which ones of them have lawyers to help, and which ones of them cannot vindicate their rights? That's what this case is about, and I turn to the Vares issue. The central submission then, my lords, my lady, is this, and it's paragraph 1.8 onwards of our case. It is the design, the function and the purpose of Schedule 1 of LASPO, Civil Legal Aid Scope, to target need, and you can say target need with a view to saving money, it's still targeting need for legal help in the context of legal rights by reference to subject matter and class. And plenty of examples of class that make sense of Section 42 if you are looking at amending it. With respect, nothing to the point that it's driven overall by public expenditure considerations. Many schemes with many purposes are driven overall by public expenditure considerations, and the Divisional Court recognised the overall public expenditure considerations at paragraph 39 of their judgment. The phrase that's been used is bearing down on the cost. It's page 33 of the bundle, and it's right in the middle of the page.
Right.
To bear down on the cost of legal aid, ensuring that every aspect of expenditure is justified, we're getting the best deal for the taxpayer, and then this. Unless the legal aid scheme is targeted at the persons and cases where funding is most needed, it will not command public confidence or be credible. Public confidence linked throughout to targeting priority need.
Can I ask Mr. Fordham, before you develop this area of your submissions, can I just ask you two questions about the point you've already made? First of all, in relation to Henry VIII clauses, are you able to refer us to any authority on how Henry VIII clauses should be construed?
Yeah. Answer, yes, we've got two.
Well, you're going to come to this, are
yes.
you? Fine. And the other question was, you had told us that equal protection of the laws is a constitutional principle.
Yes.
I can see a route into that in a sort of negative way, you know, the unreasonableness of discriminating against people and so forth. But is there any authority directly to support that proposition?
Again, I will show you
We'll come to
authority by reference to equal protection of law as a... I'll show you it in a case called Gurram.
Fine. Okay. Thank you.
But it's extremely helpful, and I really hope I don't forget. But someone will remind me if I do. Can we look at the Act and the design of the Act? And I actually want to start, if I may, with the explanatory notes, because it is quite helpful. Unless you tell me you're all over this and you really don't need this kind of stuff, I would like to just...
I'll just emphasise the point part.
I'll take this
Certainly.
as fast as I dare. It's Authorities, Volume 1 at tab 2, and it's page 3326. And just for those of you who want the map, it's been summarised in the judgments below. The way civil legal services work is they're set out at 3326 in the introduction under Schedule 1. What the explanatory notes helpfully do, and this is why I'm showing you them and not just the Act, is they illustrate. They give you illustrations and examples to expand, so you can see practically. So as an example at the end of 98, special education needs. There's then an example of how you get exclusion, but then exception from exclusion in Part 2, and that's paragraph 99, and then you get advocacy restrictions. Certain sorts of advocacy are included and certain sorts are not, and so on. So that's the general mechanics of it, and with examples. There was then an extremely helpful annex to the explanatory notes that accompanied the Act. That's at 3330.
Thank you.
And it goes through each of these paragraphs as our explanatory appendix does. And again, it's what's really good about it is it gives practical examples. So 822 tells you, includes where the local authority is considering commencing care proceedings. They're going to take your child into care. End of that paragraph, seeking to take the child into care. Then you get guardianship orders in 823. 824, local authority assessing a child's special educational needs. 825 tells you why there's a second limb to that. It's to bring in those aged 16 to 24 as alongside children with special educational needs. Now, quite a good example, that, of a class. And you might reprioritise, and maybe it would be inhumane. But you might say, for the future, we're only going to include the children. Parliament decided to include 16 to 24-year-olds, but we've got a Henry VIII power, and providing that we exercise it in accordance with the purpose of the statute, we will reprioritise. But there is all the difference in the world between that kind of measure and one that says keep it if you're 16 to 24, but not if you fail a residence test. And that's introduced a criterion that has nothing to do with need, and for that matter, nothing to do with cost either. It's not that these cases are more expensive if you fail the residence test for the state. Not that that would be a good reason. 827, again, gives you example at the end of the paragraph. Services in relation to claims by individuals who allege abuse in local authority care. So you've been abused in a British local authority care home, and you've got a claim. Over the page, bottom of 3331, 836, services relating to the court of protection, property, financial affairs and personal welfare of people who can't make decisions for themselves. That's how they have been assessed, and decisions are going to be made. And then advocacy for them, bottom of that page, certain vital interest of the individual concerned. For example, the right to life, liberty or physical safety. Now, they've reprieved liberty in relation to the residence test, but not other cases. So you could have very intrusive measures being taken by a British public authority against an individual who is here in Britain and is vulnerable and said not to have any mental capacity, and they're there before the court of protection and they are excluded. Next case in the list, exactly the same. Meets the test, no problem. So that's the structure of it. I'm not going to take you through the rest. You get the flavour. And I will say this, if there were one document I could get you to read in this case, it would be our explanatory appendix, although it is very dense. It's designed to show you, so that you are in touch, what these cases mean in reality. And they are not marginal cases. This is not choose some harsh ones near the boundary to try and illustrate that a rule is unfair. They are paradigm cases. And if there are other paradigm cases, Mr. Eadie will tell us what they are. Then the other features of the scheme, just so you see them in the explanatory notes, there's obligatory legal aid. That's where it would be a violation of a fundamental right to refuse it. Nothing to do with discrimination, but a breach of Article 6 or EU law. That's paragraph 104 of the explanatory notes that we are looking at. So that's page 3327.
Thank you.
Eligibility, you know all about that. Means and merits, paragraph 95. On the previous page. Firstly, you've got to be in scope, but secondly, you've got to have an assessment of that you qualify, you're eligible, and that includes means and merits includes cost-benefit. Why do you look at cost-benefit? Because you're asking, would someone take this case on? Is it worth enough when you are comparing what it will cost? Is there a sufficient value? But it's still all about need. Means testing is an obvious basis to address need. The Section 9 redesign power is described at paragraph 96 on page 3326, and the differentiation provision, which is a general provision, but in our case, of course, has to come in support of the Section 9.2 power. It can't reach beyond it, is at paragraph 279 on 3329. The Act itself is at tab 1 of the same volume.
Yep.
If you look at 3201, page 3201, and the long title, I'd have to accept there's a multiplicity of purposes for LASPO, but that's because LASPO does lots of things, only one of which is legal aid. In fact, it also deals with criminal legal aid, even in part 1 of LASPO, but it's dealing with sentencing, release on licence, bail, employment of prisoners, it creates new offences, a new self-defence provision, and all of that you see from that long title. So fine, there is a multiplicity of purposes, but that's not going to help us when we're looking at the vires of a very specific provision. And again, cardinal point in this case, Parliament did not say you can amend this Act. The Henry VIII provision in section 9.2 is very specific, and it only permits, not even the amendment of Part 1, it permits the amendment of Schedule 1. Now, Part 1, we've got, Part 1 does various things. I mean, for example, Part 1 abolished the Legal Services Commission, section 38 on page 3237. They thought it would be more efficient to deal with legal aid in a different way, so they abolished the Legal Services Commission. 3237, section 38. It deals with permitted providers. at section 27 on page 3228. But for our purposes, it deals with scope at section 9. You've got that at 3208. And then in Schedule 1, to which it refers, with the Henry VIII power, as I've said, very specific in 9.2, may by order add, vary or omit services in Schedule 1, whether it's the in scope, the list of the 45, or whether it's changing the rules in relation to exceptions from exclusions, or whether it's changing the rules in relation to permitted advocacy. And you've got Schedule 1 starting at 3247, and there are all those listed priority pressing areas for civil legal aid. You've seen already in the explanatory notes, but I'll just locate them on the map. Means and merits come in via section 9.1b, and then section 11 for merits, and I made the cost-benefit point. You see that at section 11.3. I've explained why that's obviously part of need in its own right. And means testing, it comes in section 21 through financial resources regulations that are going to be made by the Lord Chancellor. You then get other ancillary provisions, quite important for a reason I'll come back to see section 12, 12.2 and 12.3, regulations about determining legal aid and about applications for legal aid and about what applicants have to provide when you're asking for legal aid, because we've got a Court of Appeal case about the sort of evidence that was sought in domestic violence cases. It's a very revealing case. We'll come back to it. Henry VIII, you've seen provision number 1. There are two others that we've found. Section 17.3 on page 3217 is a Henry VIII provision. The Lord Chancellor may by order amend subsection 2. So again, it's specific. You can add or vary a factor. These are the interests of justice factors for the purposes of qualifying for criminal legal aid. If we had a case on that, there would no doubt be arguments about what's the purpose here, what's the design, function and purpose of all of that, and can you really step outside it? But could you have a residence test? In principle, could you add that as a factor? Would that be with the grain or purpose of the legislation? Is it really the interest of justice to say to people who are identically placed, one of them fails? So that's the first additional power. There's one more, which is section 19.5 on page 3219, an ancillary provision in relation to determinations of legal aid by courts. That's section 19, bottom of 3218. You're going to have regulations about that, and then you can have consequential provisions that modify acts. So those are the Henry VIII clauses in Part 1 for legal aid.
You're going to deal with the relationship between Section 9 and Section 11. I mean, it seems to be being argued under Section 9, but I mean, at first sight, we're not talking here about restricting services. We're actually talking about deciding who's going to be entitled to the services, aren't we?
Well, let me be very clear. If the question were, could Section 11 be used to introduce a residence test, my submission is that it plainly could not. It would run...
I mean, that sets out very clearly the criteria,
yes.
And it doesn't include anything you would say which covers
no,
residence. But isn't that a sort of indication that that's not really what Section 9 is about?
Yes, it is. And there's no, we've just seen it in 17. There's no 17... 3, the way it works is that these are the statutorily mandatory factors, but the Lord Chancellor then has to make his eligibility, his merits criteria. But I will come, again, I'll come back to it, but I hope that in the stride of my submissions, and in fact it supports me, that there is a specific Henry VIII provision.
It's never been argued, has it,
No, it
that
hasn't.
Section 11 would cover it? No.
And I certainly made the submission below and repeat it here, that you couldn't do. You couldn't do it under financial provisions either. The financial regulations don't even have affirmative resolution. They have negative resolution. And the financial regulations, suppose you had one that said they're different. They're different for foreigners, or they're different for people who don't meet a residence test. The means test is different. If you've got £1, you can't get legal aid, whereas for British or those who meet the residence test, it's £1,000. My submission would be the same. One can see the purpose of this, and one can see how gravely this provision conflicts with it. Just before we leave the Act, can I show you section 32, which confirms that civil legal aid is for English law, unless a foreign law is relevant to English law. So what you were giving me? Oh, I'm reminded that use of section 11 would also have the problem that you wouldn't get the exceptional funding safety net because of the way the Act is structured, but that's another indicator. I was showing you section 32, top of 3232, it's the law of England and Wales, and then section 41 we need, because that's the general provision about all orders, regulations and directions can differentiate. You can differentiate generally or specifically circumstances or areas, periods and so on. Proceedings before particular courts or tribunals, classes of individuals. The word used is class, and that's what's relied on here. We've found a class under section 41(2)b. We are then using our section 9(2) Henry VIII power to identify a relevant class. It is not difficult in LASPO to find the kind of class that is intended and that reflects the statutory purpose. It's the class of person who is the victim of domestic violence, for example. There's a policy choice in the legislation that the legal aid is for the person who claims to be the victim of domestic violence because of particular needs considerations and self-help considerations. You don't get legal aid if you are the person accused of domestic violence. You've seen the categories: children, vulnerable adults, and so on and so forth. So no difficulty with seeing the sort of class examples. If I can just give you one page reference in relation to the point I've just made to illustrate that point about the victims of domestic violence. Yep. It's in volume 2A, and it's in the bundle at pages 600, 602 and 604. 600, 602 and 604. And you'll find passages on those pages that are addressing where are we drawing the line. Are we drawing the line to include every case? And you see it at page 600, about 10 lines up, the third bullet point from the end of paragraph 18 under a heading.
Where victims of domestic violence.
But the other parties does not. And the argument was that's not fair, you can't draw that distinction, and they follow that through and they decide, no, it's different if you are the person who is the victim. That's the sort of class example that the Divisional Court recognised, paragraph 14 of their judgment and paragraph 49 of their judgment. And there are other similar examples. You've got to be, for example, the family member who is seeking the protective order to prevent a child being taken out of the jurisdiction. Emergency protection to stop my child being taken away. That's where the legal aid, the priority legal aid, is allocated, and it's on the face of the statute in those kinds of cases. Similarly, for inquests, it's relevant family members that are within scope for legal aid. Lots of examples in all these decision documents if you are interested in seeing more, but you get the point. Now, what about amending Schedule 1? And if we go back to the Act, if you've still got it, in the authorities at Volume 1, Tab 1, I just want to show, my lords and my lady, that the sorts of amendments there have been a fair few, and the way it works, my lords, my lady, is this, that in the helpfully annotated statute, picking up Schedule 1 at the bottom of page 3247, every time after the provision and after the line across the page, it starts with notes rather than commencement. Bottom of 3248 is the first example. Special educational...
3248.
3248, bottom of the page, special educational needs, sets out the provision, then has a line, then has notes. If you've got notes, that means there's been an amendment. And you can trace them all through to see the sorts of changes that there have been. It gets updated, words get inserted, new sorts of proceedings are invented by statutes and they're included by amendment of these provisions. On occasions, there are new categories to match new protections of the law that go alongside these priority areas. And so you see special educational needs. Now, that's an example of primary legislation amending Schedule 1, and there are plenty of examples of that. I'll just show you one more. 3262. 3262. 15A is completely new. Female genital mutilation protection orders. And that's inserted by primary legislation, the Serious Crime Act 2015. There are, in fact, 3 examples of new areas.
Okay.
Henry VIII amendments, if my lords, my lady, look back to page 3254, you'll see a new category for appeals relating to council tax reduction schemes. This is described by the Divisional Court in their judgment at paragraph 18. That's a new category added in. The reason was that what had been included within category 8 was council tax benefit and appeals from council tax benefit. They changed the law. That was taken away. That was given a new name and a new scheme, council tax reduction schemes they're called, so appeals related to those had a new provision. That's 8A. And at paragraph 49 of the Divisional Court's judgment, you'll see another example of that described. You'll find it on page 3258.
Sorry, did you say 49?
Yes, paragraph 49 of the Divisional Court's judgment. Yep. And here, if you look for the line at the bottom and the word notes, what the court finds is that a definition is substituted by a statutory instrument. The definition relates to domestic violence. There was a new cross-government definition of domestic violence. In fact, it was raised during the passage of LASPO. Have you got the right definition? There's an amendment power. It's used under the Henry VIII provision to update the domestic violence definition. A good practical example. And there are examples that relate to changing the advocacy provisions in the later parts of Schedule 1. I'll give you just one reference, 3301. Middle of the page, after the line notes, you then get a whole lot of examples of advocacy services that are added in the context of family court proceedings. I would like to show you, just by way of a good illustration of how this works, in case there's any idea that our argument stultifies the power, it's meaningless, it's a straitjacket, you can't do anything. What these countless examples, and there are many more, look like in practice. And if my lords and my lady, with that in mind, would please look at tab 6 of the same volume, Authorities Volume 1. Electronically, it's 3459. 3459. You'll see here is an order pursuant to the Henry VIII provisions, 9.2 with 41. What does it do? You can see from 3460, what I just showed you, council tax reduction schemes. 3461, what I just showed you, definition of domestic violence. There's also the inclusion of services within category 18 that are Hague Convention cases, and there's a technical amendment to the judicial review provision, paragraph 18 at page 3463. If we look at the explanatory memorandum that accompanied that statutory instrument, it's at page 3467. and turn just one page to 3468, the court will find, I hope, a heading, paragraph 7, policy background.
Yes.
If you look at paragraph 7.1, it hits the nail on the head. The Act gives effect to government's policy position. The government believes legal aid is expanded far beyond its original intentions, available for a wide range of issues, many of which need not be resolved through the courts, irrespective of the current economic situation. A wide-ranging programme of reform is required. And then this: to ensure that legal aid is targeted to those who need it most for the most serious cases in which legal advice and representation is justified. And that's it. That's the purpose, accurately identified in the explanatory memorandum itself. Ironically, perhaps, the explanatory memorandum for the draft order that has the residence test in it also repeats that position. But there is the most obvious discord, as Lord Justice Moses described it in the Divisional Court, between that on the one hand and what's actually happening in relation to the residence test, because it doesn't prioritise on the basis of need. It introduces something that is wholly extraneous to need.
What's your best citation of an equivalent statement before the 2012 Act?
Yes. The decision document at bundle, you find it in our case at paragraph 117.
117.
1.17.
Right.
But let me just see if I can track down the bundle reference. If my lords, my lady, would please turn to page 519 in volume 2A. And at 519, you don't need to get very far into the ministerial forward of the then Lord Chancellor alongside his photograph to see legal aid scheme, a vital part of the system of justice, one that needed fundamental reform to ensure access to public funding in those cases that most require it. Top of the next page, exactly the same. The aims are to discourage unnecessary and adversarial litigation at public expense, to target legal aid to those who need it most. And then penultimate paragraph on that page. Many respondents raise concerns about access to justice, especially for vulnerable groups. I believe the plans I'm bringing forward protect fundamental rights to access to justice while at the same time achieving a more affordable system. This is reflected in the retention of certain areas of law within scope, but also in the new exceptional funding scheme for excluded cases. So the scope of Schedule 1 and Section 10 exceptional funding are intended to secure access to justice. And finally, at 524, well, I don't know how much you want. 524, paragraphs 9 and 10. 527, paragraph 5. Perhaps that's a good one because it's got the heading rationale. Rationale for proposed changes to scope, 527. Proposal for reform designed to refocus on those who needed it most, the most serious cases in which legal advice or representation were justified. I'm sorry, I should have said 5 minutes ago, page 527, paragraph 5, first sentence, because you asked me for one. But my lords, my lady, I hope can see the clear theme. Now, you can find this point wherever you look. It's in the witness evidence of Miss Gibby at page 2421 in volume 2E. I'm not going to ask you to turn it up. The Divisional Court referred to it at paragraph 39. And we give all these references in paragraph 117 of our printed case. What's gone right? Paragraph 40 of the Divisional Court's judgment. Page 33. The statutory provisions read as a whole demonstrate that which the Lord Chancellor publicly and repeatedly avowed, you've just seen it publicly and repeatedly, was to be achieved by a process whereby services were identified according to his assessment of where civil legal aid was most needed. No other criterion emerges from analysis of the statutory provisions. Then this goes right, we say. The power to add, vary or omit services under section 9 as supplemented by 41 is to serve and promote the object of the statute. I'll show you it in venue. The secondary legislation provides an opportunity for the Lord Chancellor to add, vary or omit those cases where from time to time he judges a greater need has arisen or a lesser need has emerged for distribution of civil legal aid. If the premise is right, that you can discern that purpose from the statutory scheme, then the consequence, the conclusion is right. Unless Henry VIII provisions are really to be permitted to allow the executive to change the purpose of the statute. You can't just change the act, you can change the purpose. You can change the ethos. You can have a different aim.
Where were you reading from then? And
Sorry?
that last passage, where was that? Where did that come from? I missed it. Where were you reading?
I was reading paragraph 40 in the Divisional Court at page 33.
Could I take you back for a moment to the point that was raised by Lord Carnwath?
Yes.
Lord Carnwath raised with you the fact that section 11 is the provision which governs whether an individual qualifies under Part 1 for civil legal services. And it deals with the criteria, and section 12 deals with the individual determinations.
Yes, it does.
Yeah, now in section, and Lord Carnwath was asking about relationship between that and section 9. If one goes back for a moment to section 9, subsection 1 lays down two conditions for civil legal aid, for civil legal services to be available to an individual. Under A, the services have to be civil legal services described in Part 1 of Schedule 1. And under B, the director has to have made a determination that the individual qualifies. And that would be a determination under Section 12, applying the criteria laid down in accordance with Section 11. Is that right?
Yes, I think it's determination under 11.1, but my right.
Fine. And then the power we're concerned with is the power under subsection 2, and that power relates only to subsection 1A, the designation of the services.
Yes, it does.
Okay? So one might perhaps take from that the power is concerned with the designation of services. The question of whether an individual qualifies for the services is a distinct issue, which is not the subject matter of the power conferred on the Lord Chancellor.
I need to be careful because I've shown you an example of the redefinition of domestic violence. Mm-hmm. And I have accepted that that's an updating example of amending Schedule 1. Yeah. Now, because Schedule 1 was enacted in the terms that it was, that kind of change would need either primary legislation or the use of 9.2. Mm-hmm. I have not previously, and I'm not about to, submit to you that that sort of change is out because of the use of the word services in Section 9.2. If that's, and that's the reason why I'm not making that submission, but so I'm not saying that a change of that kind wouldn't be a change to the services. What I wholeheartedly submit to you is that the examples I have just shown you are not just illustrations, they show you the nature of the power when you are amending services. And to bring in something extraneous is contrary to the purpose, and perhaps I should add, that is supported by the fact that the focus of 9.2 is on services.
But I think the point that's being made to you is a supportive point, not a challenge.
Yes, no, and that's why that's how I understood it. I just didn't want to go back on something I'd said 2 minutes earlier.
Yes, but if the Lord Chancellor, by order, adds providing advice or advice and assistance or representation in relation to domestic violence, there was no problem about that, is there?
No.
And I respectfully agree it is a supportive textual point on the face of the statute itself. You put it together, what's this power doing properly construed? I do it, I do it by reference to purpose, do it by reference to text. If you said only legal help for a boy with special educational needs and not a girl, I know that's a red-haired teacher example, but suppose you took that as an example and said, could that possibly be either consistent with the purpose of the design of the schedule, and of course not, could it be consistent with what was envisaged when you said you're changing the service? No, it's not. Mm-hmm. And I respectfully agree, it is both supported. And I do.
Well, I'm raising the point because the argument you're putting so far has really been a sort of Cruz and Johnson point, that that the way the power has been exercised is so unreasonable and so remote from any purpose one might think Parliament had in mind, that it can't be intra vires. And I'm just wondering if there's perhaps a narrower argument, yes, to do with the text of the statute, which might support your conclusion.
Well, I'm very grateful. I'm not intending to put a Cruz and Johnson point at this part of the argument. I'm not saying, here's a power that is at large. Do what you think appropriate. Amend the Act. But you can't have delegated legislation that's partial and unequal. I will say that when we get to the second point, if we do. At this point of the part of the argument, it's ultra vires. You might say it's close to a Padfield type argument.
Yes.
Frustrating the purpose.
Exactly.
And I wouldn't disagree with that. But certainly, interpretation of the statute as to its text, as to its structure, as to its function, as to what was said about it, they all point in the same direction. And the conclusion is a black letter, hard-edged legal conclusion of ultra vires. Nothing to do with Wednesbury.
A black letter is ambiguous. It seems to me that this appeal does raise quite an important point indeed an important point about the proper approach to Henry VIII clauses. Mr. Eadie says that you construe any provision in a statute by looking first at the ordinary meaning of the language, and that is a black letter approach. Only if there's an ambiguity do you then resort to a narrow construction.
Yes.
And his submission is that Henry VIII clauses are just like any other clause. You, I think, are saying no, that when you're looking at a Henry VIII clause, you do not take a simple grammatical approach and say, well, if on a black letter interpretation of those words, it's within the power, that's the end of the question. You say that when you're looking at Henry VIII clause, you've got to see whether the power exercised goes with the grain of the legislation.
Right. Can we look at...
Now, that's a rather important point.
Yes.
You were asked earlier, Lord Reid, whether you're going to come to authorities on that point.
Can we look at Benyon?
Right.
On that point. It's volume 10, tab 107. And it's page 6836.
Okay.
And it's headed section 59, delegated legislation, the rule of primary intention. Immediate question that will be in your minds is that delegated legislation when it's Henry VIII legislation? And the answer is yes, that is delegated legislation. But just to make that good, if you turn the page to 6837, you'll find that Benyon's example 59.1 is a Henry VIII example. They had a mistake in a schedule to enact. They used a Henry VIII provision to correct it. Back to the rule, section 59, 6836. There are various types of delegated legislation. All are subject to certain fundamental factors. Underlying the concept is the basic principle the legislature delegates because it cannot directly exert its will in every detail. All it can in practice do is lay down an outline. Or for Henry VIII, you might lay down quite a detailed outline but need or want to have a power to amend it. This means that the intention of the legislature as indicated in the outline, that's the enabling act, must be the prime guide to the meaning of delegated legislation and the extent of the power to make it. So when I look for the object and purpose, in order to delineate the extent of the power to make the delegated legislation, I am adopting in my submission a perfectly orthodox approach to statutory construction. And yes, it's black letter in the sense of the words on the page, but it's also what's the essence, what's this showing about what the object of the legislation was. And that's why Lord Justice Moses is right in what I just was submitting. He goes from step 1 to step 2, premise to conclusion, correctly. Further down the page, Benyon tells us in the comment, you get a top tier of enabling act and a second tier of delegated legislation. The delegate is not intended to travel wider than the object of the legislature. The delegate's function is to serve and promote that object while at all times remaining true to it. And I ought to just make this link. In the next quotation, you'll find a reference to the phrase strictly ancillary. And whether intentionally or not, almost certainly intentionally, I think it's right to draw the link to the Lord Chief Justice's speech of last week that you've got at tab 128 in volume 12. Very interesting speech about...
The former Lord Chief Justice.
I'm so sorry, former Lord Chief Justice, I do apologise. About Henry VIII provisions. I don't have the time, but perhaps you will have a look at it. But at the bottom of 7741, at the end of that speech by the former Lord Chief Justice, unless strictly incidental to primary legislation, every Henry VIII clause, every vague skeleton bill is a blow to the sovereignty of Parliament. That's the view that is expressed for good reason, given earlier.
Can you just go back, Mr. Forden,
Yes.
for me to 6836, to the Benyon quotation?
Yes, my lord.
Delegate is not intended to travel wider than the object of the legislature. The two cases cited are Gorris and Scott Phillips. The second of those is, speaking from recollection, does the statutory duty create a criminal offence, yes? What about Gorris and Scott?
That's a case about the sheep being on board the ship.
No, well, don't worry. We haven't got it.
We
yet.
will
can-
check.
we
We've
can
got
do it in due
we've got Utah, which is the first footnote over the page, but that's not particularly going to.
On MS 6838, Section 81 has a discussion specifically of Henry VIII clauses, and we've got Lord Bridge quoted, footnote 102.
That's where I'm coming on Henry VIII, because what I've shown you about delegated legislation is all delegated legislation, but it has a particular bite when you're amending the statute. Because if you have to stay faithful to the purpose when you're doing something that is truly tier 2, you're filling in the details, you're making regulations about how people go about applying for legal aid, that's one thing. But even when you can redesign the statute, you have to stay true to the object and purpose. You can't expand it. That becomes a very important controlling factor in relation to Henry VIII provisions. But my lord,
Can I just follow up one thing, because I'm not quite sure that I'm clear in my mind where your precise answer to Lord Reid and before him Lord Carnworth is in relation to the interrelationship between Section 9 and Section 11. You mentioned domestic violence, but it seems to me that domestic violence is a category of service which necessarily is to some extent defined by reference to individual relationships. So it, so to speak, crosses perhaps a boundary and can be regarded as a category of service.
yes.
What is your precise attitude to the suggestion that in truth here we're dealing with a definition of or the scope of services, whereas if you wanted to define entitlement by reference to the type of individual characteristic which has nothing to do with the services, such as residence, may affect the taxpayer but has nothing to do with the services, you should have been looking to Section 9(1)(b) and the power to determine whether an individual qualifies under Section 11, which obviously hasn't been thought wide enough to be relied upon in the draft order, since it's not one of the enabling provisions relied on. What is the
My
precise answer?
precise submission is that services in 9.2 means services of priority need. It means services that people need. Needed
and therefore
services.
you would accept then the point, which I think was being put, namely, that if you wanted to make this particular type of residence qualification critical, you would have to try and find the authority in Section 11.
I accept that you can't do it under Section 9.
Yes, and you may be... And
my submission unhesitatingly is that you wouldn't be able to do it under Section 11.
Yeah, and it hasn't been relied on.
And we'd be back to... We'd be then in even more conventional territory, because you're not Henry VIII at all. Your regulations under the object and purpose of the statute, and all the arguments would be the same. So I'm certainly not veering towards or asking this court or inviting you to get to a position where there is an open question about whether this could be done, but it just needs to be put in a different box. It needs to be done under Section 11. And there's good reason why that's never been relied on. If you want to revise the scope, it's Henry VIII and its Schedule 1.
Section 41 would enable you under Section 11 to distinguish between particular classes of individual, but certainly none of the factors in Section 11(3) would be easily applicable. I suppose the public interest might be, but anyway, that's an argument which doesn't arise.
Well, you say it doesn't arise, but in a sense you want us to deal with it.
Yes, please.
Fine.
Yes, please, absolutely. If it were a good point, it would have been advanced, and if Mr. Eady wants to have a go, he'll have a go. But it's this residence test is ultra vires a statute. And one of the virtues of a prospective challenge, which you'll appreciate this is, hasn't been made. And that's why you've sat urgently to deal with it, is we get this clear. We don't go back and find that we have to start in the divisional court by reference to now invoking a different power. But my submission in answer to my Lord Mance would be exactly the same when we're looking at the word class at the bottom of 3239. What does class... I've already, I hope now, answered services with gratitude. Class, same thing. Class referable to need. Class referable to
Sorry,
need for
class?
referable to need for services.
Thank you.
Not class independent of need for services. And that would go right the way down the line. Financial provisions. Could you have a residence test? £100, as I've said, or £1? No. Because when you differentiate between classes, it's got to be for a relevant reason that reflects the purpose of the statute. Same for merits, Section 11. Same for scope, Section 9. It's a differentiation power, it's not a discrimination power. It's not a discrimination power so far as people who are identically placed, same needs, same means, same merits, and so on. But my...
Needs, means and merits are the
those are the three
categories.
hallmarks.
You could say that 11.3 factors essentially go to a cost-benefit analysis. Part of it at the end is the conduct of the individual, which goes to merit, which comes in a sense within a cost-benefit analysis.
It does.
And then the public interest, you would say, has to be read not as absolutely opening up anything at all, but in the same spirit as the previous paragraphs.
Exactly so. That's exactly what I would submit. And need is objective. So government has said, and they've got their factors, we know what 4 factors they applied: importance of the issue to the individual, opportunity to self-help, could someone really go it on their own? Other options, can you get this sorted by another means? Other sources, is there other funding? Is there some free advice service that can help you? And those were the factors that were used to identify what is within scope. But need, importance, these are objective matters. If they say, we are going to put into scope serious abuses of power by public authorities, and if you look at the way serious abuse is defined in the statutory scheme, you'll see just how extreme and important that category is, because it's basically knowingly harmful abuse of power. It's almost misfeasance. It's page 3268. Deliberate or dishonest abuse of power resulting in harm to a person or property that was reasonably foreseeable. Page 3268, category 21. Now, there's an objective assessment of need and importance. Same with equality. Why is it important that we fund discrimination cases where people who are victimised or harassed in a discriminatory way? It's because those cases have a priority. There's an importance to them that is objective. Same with judicial review and holding the state to account. But all of that is with the grain of need, and cost benefit is with the grain of need, because you're looking at what would somebody of ordinary means, whatever that means, do in this situation? Would they take this further? Would it be worth the candle? And if they wouldn't anyway, because it's not worth it, then the person who would otherwise need the public funding isn't losing out. And that, again, is a feature that goes with the grain of the statutory purpose. We were at Bennion, and it was put to me that 6838 is a description of Henry VIII provisions, and what Bennion says is narrowly and strictly construed, 6838, and the footnote is 102.
Yep.
And we've got those authorities. I don't know whether you want to see them. We've cited them in our printed case.
Perhaps if we look at them in your printed case, it's the most efficient way of doing it.
Yes, I think it would be. So it's paragraph 2.2.
Thank you.
Sorry if it sounds like I haven't gone very far. But paragraph 2.2 happily is at 6953.
Yep.
We cited Bennion there. Spath Home, McKiernan, the then Master of the Rolls, Lord Donaldson, a delegation to the Executive of power to modify, page 6953, delegation to the Executive of power to modify primary legislation must be an exceptional course. If there is any doubt about the scope of the power, it should be resolved by restrictive appeal. And that was confirmed then by the House of Lords in Britnell and by, in the Spath Home case.
Well, judging from the footnote, and it might be thought that the Spath Homes was sort of stepping back a little way from Britnell.
Well,
I'm not sure that's right.
Let's look at Spath Home, because I lost count of how many times Mr. Eady referred to it. Paragraph, tab 16 in volume 2 at page 3665. I'll take this as quickly as I can, but there's actually quite a lot here. If you start, please, at page 380 in the report, 3696 in the bundle,
Thank you.
you'll find the Henry VIII power. And what the case is about, it's at letter F on page 3696. It's a reserved power to limit rents, and the issue in Spath Home is, was that power to limit rents only for the purpose of inflation protection, or did it extend to a purpose where you could restrict the rent even though the landlord said it was unfair because the landlord had failed to collect what earlier could have been collected, and so in fact the increase looked far worse than it was. That was basically what it was about. But the Henry VIII provision is section 31(2), and you can see quite unsurprisingly that 31(2) is going to take its function from 31(1), because the rent limitation power is what then has the supplementary provision for Henry VIII. I only make that point for this reason. Spath Home then looks in detail at the statutory purpose of section 31. And the link we have in our case, though it's not identical, is we have the clear link between Schedule 1 scope and Henry VIII. It's not at large. It's specifically linked.
Understand. Yep.
Now, you get Padfield,
Yep.
B to C on the next page. but it's a Vares argument that's being advanced. No unfettered discretion at E. The object is to ascertain the statutory purpose or object the draftsman had in mind. At letter F, you start with section 31, so all conventional. And then if you look over the page at 382, between B and C, and this is the first point of departure for us, just above B, because the Act covered a number of aspects, one cannot discern any very specific unifying theme in the legislation. On the face of section 31, it's very broad. We have got a very, very clear unifying scheme in the legislation. We've found it everywhere we've looked, including in what the Lord Chancellor was saying in designing LASPO. It's fair to say that it's identified by all 6 judges below, because the Court of Appeal is with us, we say, on the statutory purpose being priority need of Schedule 1. I'll show you that. Then we get McKiernan, Lord Donaldson, endorsed in Britnell by the House of Lords. So you see the quotation at the bottom of the page from McKiernan.
Yeah.
And then the conclusion of Lord Bingham, it's only appropriate where there's a genuine doubt about the effect. Genuine doubt about the effect. Now, it's a typical advocate's thing. I say there's no doubt. It's obvious that we're right. It certainly is not the case. It's obvious that Mr. Eadie is right, and this Henry VIII provision is so expansive that you can introduce a new object or purpose to the design of civil legal aid. And I accept, of course, I have to, that if there is no doubt, you're really clear that the Henry VIII provision really is that broad, having regard to the principles embedding the design and purpose of this Act. It's not going to help me. Then Lord Bingham goes on to discuss letter E at 384, lack of a specific purpose, but he wants to trace back section 31 to its source to understand it, and he then does that. He looks at predecessor statutes to look at the mischief. He cites authority on 3703 about official reports being relevant, part of the context. That's at letter D on 3703. He describes the position of putting yourself in the draftsman chair to try and understand it. That's letter D on 3704. Understand the provision. So for him it was section 31. For us it's Schedule 1, or Part 1 of the Act. To understand its function and purpose. And at the end of that paragraph, just below E, it's appropriate to consider the statutory predecessor to section 31. So that's my point. You're not looking at the Act at large with various different functions and purposes. For us, that would include criminal sentencing. You're looking at the relevant part to which the Henry VIII provision relates. He concludes, Lord Bingham, at page 390, at letter D, that the purpose of section 31 was broader, and he explains why, by reference to history and predecessor provisions. It wasn't just inflation protection. And at letter B on the next page, he's describing the predecessor provision of section 11. It couldn't be said that there was a sole mischief of the predecessor provision. There wasn't a single purpose or object. Finally, at letter G on 3708, I don't regard the meaning or effect as ambiguous or obscure. The unease I felt, he says, on reading it in isolation has been dispelled by considering it in its social or factual context. So, what you get from that is, first of all, you are looking at the provision in its context and setting. Secondly, it is relevant to look for purpose. That's what Lord Bingham started by saying. Thirdly, you are looking to see whether there's a unifying object or purpose for the relevant provision. And finally, unless it is clear, crystal clear, beyond any doubt. You read it narrowly, you read it restrictively, not just meaning, effect. That's the word at the bottom of 3698. I wouldn't accept that Lord Bingham was cutting back on that principled approach, correctly understood. The principle is in place and it must mean something. What does it mean to take a restrictive approach to the effect of a Henry VIII provision? Well, one obvious answer to that is that you hold to the purpose and object of the relevant provisions that you are being given an exceptional power to redesign. I made the point that, respectfully, the divisional court went right in going from premise to conclusion. Can I just make the opposite point as to why, with respect, we say that the Court of Appeal goes wrong in relation to premise and conclusion? If we start at paragraph 21 on page 11, in fact, if I can go back a page to page 10, my lords, my lady will find Lord Justice Laws for the Court of Appeal, bottom of page 10, paragraph 20. This is when he's talking about Hansard and parliamentary material. Third line in, to the extent that counsel seeks to rely on statements in either house to establish the central importance attached to need in the evolution of policy relating to civil legal aid, that is amply demonstrated by the department's own published documents, and counsel hasn't sought to contradict it. So we've got that. Then Lord Justice Laws tells us at paragraph 21 over the page, halfway through that paragraph, he's dealt with a view to saving public money. Yes, you're saving money by targeting greatest need. The reality, he says, is that need and cost are not strange bedfellows. Then this, it must be obvious that in circumstances of financial stringency, choices as to the disposition of public funds in a particular area will focus on need for the service in question. Thus, it is not merely unsurprising that Part 1 of Schedule 1 lists categories where the need for civil legal aid is pressing. It is, in effect, inevitable. I emphasise must, obvious, will, unsurprising, and inevitable. I also emphasise necessity in the next sentence. But here's where it goes wrong. We know, we can see it on the face of the statute. Lord Justice Laws tells us it's obvious, it's what you would have to do, it's inevitably what you'd have to do, that the purpose is priority need. You are focusing on priority need. It goes on, though, to say, but that doesn't mean that that's the only criterion by which the Lord Chancellor may limit or restrict civil legal aid.
You say it's fine up to the last sentence
Yes,
of 21.
That means the Lord Chancellor can use this exceptional Henry VIII provision not to redesign, but to expand purpose and object.
Understand?
Well, no, in that sentence, on face of things, Lord Justice Laws is assuming that Section 9 is the only means available for Lord Chancellor to limit or restrict
Yes,
the provision of civil legal
the
aid.
history is it's never been said that this could be done by Section 11.
No.
And there's good reason for that.
Yes?
While we've got it, he also recognises in the next paragraph, about 8 lines in, the contents of parts 1 and 2 no doubt reflect a judgment by the legislature that cases represent needier cases than the latter, though those that are in than those that are out. I've read you the rational and humane bit. He also accepts that there is limited scope for change on needs grounds, and he refers us to a departmental memorandum that had been cited by the Divisional Court, paragraph 41. Now that's actually quite important, because that's effectively an explanatory memorandum at the time of the passage of LASPO, describing what this power is for, and it is just as admissible as an explanatory memorandum to the statute would be admissible to understand the purpose and function. In the Divisional Court's judgment, as we've just seen, it's paragraph 41. You'll find it on page 34.
Thank you.
And I can take it, if it's all right with you, from the judgment, page 34.
Very convenient, yep.
Giving you, if I may, the references. So the quotation comes from a memorandum that's in volume 2F at page 2743.
Thank you.
We deal with all of this in our printed case
Yes.
at paragraph 125, where you'll find all these page references.
Thank you.
And if we look at it, here's how the power is described. Will allow for services to be omitted if they're no longer needed or it's no longer appropriate for them to be listed. And then examples. Particular court proceedings are moved to a tribunal. Ceases to be appropriate because you can self-help, is the rationale. People don't need as much legal help when they're in a user-friendly tribunal. The power can also be used to add new exceptions. It's appropriate for there to be a limited power. That's how they described it. It's appropriate for there to be a limited power to amend Schedule 1, to allow it to be kept up to date, and then this. Their words, not mine. As this is a power to amend primary legislation, it is to be drawn as narrowly as possible. Then the point is repeated. The page reference is 2756 in volume 2F, and repeated again at 2787 in volume 2F. A focused power to omit services where, for example, funding may no longer be necessary. Hence, the discord. Now, Mr. Eadie says, well, we've cherry-picked one part of a great long story of the birth of LASPO and its design. Well, we haven't, nor has the Divisional Court, with respect, cherry-picked anything. We've taken the very memorandum that describes each delegated legislation power. We've taken the very passages that describe this legislative power, the one that is relied on. We've taken the very nature of the power that is still being exercised. It's an exclusion, it's a restriction. It is true that when it was put through the parliamentary process, it was rather unbalanced, because you could take away but not give. The way the power was initially designed in the statute, you couldn't add things in. The point was made through the parliamentary process. That's not very sensible. It's not a very balanced provision. You should be able to add as well, and I've shown you examples. One of them actually is a take away and give example. It's something comes out of relevant benefits for appeal purposes, and you get a new category 8A because you get a new species of appeal that it needs to cover. But none of that helps Mr. Eadie. Firstly, the relevant power, the power to restrict, is the one that was there all along and has been described faithfully throughout. Secondly, the power to add is of precisely the same nature and purpose as the narrow, restrictive adjustment power that was being conferred by the Henry VIII provision. And thirdly, we can say that with confidence because we can see how it was presented when the amendment was made. Can I rely on that? Yes, I can, because I'm entitled to show you the mischief of a provision, what it's aimed at, and Mr. Eadie would have to show that there was some new insight when they changed it to allow an add-in provision. They were doing something different. And for the absence of that mischief, I give you the reference, I hope appropriately, to the Hansard provision, and it's, I hope, at 2817 in volume 2F. Is that right? Yes, starts at 2816. And there it is, 2816. We're amending clause 9.2 so that there'll be a power to add or vary. It's a power to vary a service to amend the existing services within the schedule, and I'm sure if I were bold, I would say this supports everything we've been saying about service and how that is to be understood. It's correct and sensible, 4 lines up from the bottom, that you can do both. If you're going to update it, adjust it, have this narrow power, it really should be a power that allows you to give people legal aid where it's appropriate, because you've now got whatever new category it is. And over the page at 2817, there'd actually been a proposal to reverse the other bit and to take out omission. So you could only add. Well, we're not going to do that. As I have said, this is the promoter. The government amendment provides for balance in the existing clause 9. This amendment, you can give but you can't take away, would go further and actually remove the ability to omit. I firmly believe the power to omit is necessary. It gives the bill a welcome flexibility. An example of where this may be necessary is where the governing legislation behind an area of law is repealed or otherwise altered. You need to alter civil legal aid provision accordingly. Another example would be where particular court proceedings are moved to a tribunal. It may cease to be appropriate to provide funding for advocacy for those proceedings, so an amendment to Part 3 of Schedule 1 would be needed. That's exactly the description that we'd had in 3 Ministry of Justice memoranda as to what 9.2 was doing. And that's recognised by Lord Justice Laws, because he refers to that material and he accepts. You could do that. There is a more limited scope, bottom of page 11 for change. Yes, there is, and it's Henry VIII. So that is the appropriate approach as the Ministry of Justice recognised. And finally, my lords, just on, my lady, on this point, paragraph 23 on page 12. Four lines in particular, and here it is again, the unsurprising, I think inevitable fact that the contents of Part 1 of Schedule 1 are needs-based. Just stop there. If it's inevitable that the contents of Part 1 of Schedule 1 be needs-based, what does that tell you about the purpose, the statutory purpose and object, when you are prioritising for the purposes of civil legal aid scope? But, he says, that does not suggest far less require, and here's where, with respect, we say it's wrong. The expression of 41(2)b to a particular class is limited to the needs. One could have said service in section 9. Yes, it does.
Well, I think the difference between you is whether you imply the words only before needs-based in the second line of that sentence. Effectively, isn't it?
Yes, and you've seen...
I see what you say. I'm not saying you're wrong. I'm just saying that's the difference.
You've seen the divisional court recognising that no other criterion can be found. And Lord Justice Laws does not say that one can. He says it's with a view to saving money that you are prioritising on need. But he doesn't say, well, I've analysed Schedule 1 differently.
Understand.
And there are different things going on here. Mr. Eadie does say there are 3 examples. I'll need to deal with them. He says there are 3 he can point to that do introduce extraneous considerations at our submission.
And it would be quite possible to pass a statute which said the statute has the purpose of providing legal aid for those who may be taken to have contributed to it through the tax system, those in need who may be taken to have contributed to it through the tax system. But your case is essentially that if they said that, that would have been debated in Parliament, and there's nothing which contains that indication in the primary legislation
yes,
at all.
If they do that, we'll be back to argue ground 2. Because ground 2, Article 4...
Yes, I thought so. I mean, ground 2 applies as much to primary legislation.
You'd send it back to them and say you can't do that. But
what you're about to turn to, I think, is the fact that Mr. Eadie says they have done this. In
yes. Yes. Can I?
You're going to say they haven't.
I am. Can I deal with that next?
Yeah. Yes.
He's got 3 examples, paragraphs 14, 44 and 43 of Schedule 1. It's paragraph 31, 1, 2 and 3 of his printed case.
Thank you very much.
Sorry, paragraph
31, 1 of Mr. Eadie's printed case.
Yeah.
So if we can take them in turn.
Yes.
Paragraph 14 is family mediation. So you get civil legal aid, so you can get help with mediation in disputes relating to family matters. Mr. Eadie's submission is that that's not need, that is practical and economic efficiency. If I could ask you please to turn to volume 2A and page 313. You'll find this was a very helpful table that went through categories that were either going to be in scope or out of scope of LASPO. It starts at page 305. What is almost impossible to read is what the columns are doing, but you can just about see it on 306. Relevant factors. Factors for retention is the next to right-hand column. Factors for removal is the right-hand column. What they did was they took family law proceedings out and kept mediation in, and the justification is at 313.
Yep.
The importance of the issues in these cases will sometimes be of relatively high importance: family life, best interests of children. Why are we taking family law out? Second bullet point, alternative routes to resolution, and then this: in best interests of family to resolve issues themselves outside court with help from a mediator if required. Best interests required. Why do we say it's an area of priority need, we the government, to promote the inclusion of mediation? It's because it addresses your need in cases that are important. Now, there are plenty of other pages that also deal with this point. Page 244. Paragraph 469, in the best interests of those involved in private law family cases to use mediation. So this is the best thing for you. This is what best addresses those needs. Same point at 271 to 272. If you look at 271 on paragraph 4.210, best interests of the children. Final sentence, paragraph 4210. Scarce resources should be targeted to areas where publicly funded legal assistance is more likely to be justified and a practical benefit to the parties involved. We are targeting it to where it is justified and of benefit because it's in your best interest to resolve through mediation. Same at 4214 on the next page. So this new argument that there's other features, rather striking given that they say what the four factors are that they were addressing when they went through these things: importance of the issue, ability to self-present, alternative routes, alternative sources, all about need.
Mr. Eadie emphasises, despite what you say, in addition, they refer to benefit to the taxpayer by reducing the volume of business that ends up in court. So there is, he says, a financial factor which is specifically relied on.
Yes, well, I've accepted that this is prioritisation of need with a view to saving money.
Correct.
What you can't do is say because you're saving money, therefore the object is not prioritising need. And that's what he has to do. Strip that out of the object and purpose. I don't mind, we said in our printed case, a composite purpose is fine, but you can't introduce something extraneous to prioritising needs. Second example, it was equality, paragraph 43. This is his, no, sorry, I've got them.
It's paragraph 31.3 on page 703.
Yeah, 31, so I think he's done them in a different order from where they
yeah, that's right.
I'll do that one next. 31.3,
Yep.
paragraph 43. Is not need, it's wider social goals. The answer to that, it's objective importance. It's exactly what I was saying earlier. Discrimination cases, equality cases, serious abuse by public authorities, they assess the importance, therefore, to prioritise. doesn't support the idea you can bring something in that is no function of importance and therefore need
Yep.
of the individual. I'll give you just two references. Same volume, volume 2A, at 309,
Thank you.
you'll find back in our table,
In our favour.
discrimination proceedings, importance of the issues relatively high, addressing societal prejudice, ensuring equality of opportunity. Page 309, ability to self-represent. Some client groups may face difficulties, a suggestion that perhaps the Equalities and Human Rights Commission could help. And then at 256, if we go back, you'll find a discussion of discrimination proceedings by reference to the four factors that we know are being taken into account. End of 4133, nature of the issues at stake, addressing societal prejudice, ensuring equality of opportunity. 134, many litigants will be able to present their case. Some with profound disabilities may find it difficult. 135, we consider the funding for these claims is justified given the importance of the issues. And then 137, but you don't need funding if you're in a tribunal, because you've got an accessible route to justice. It's exactly the same theme as we have with reference to everything else. And then 31.2, Mr. Eadie's 31.2 was paragraph 44, which was an international obligations case. We get that at page 257 in paragraph 4141.
Yep.
And this is a cross-border case. This is where you're trying to fight a case in another jurisdiction. There are universal minimum standards. Why are there universal minimum standards? Because this is needed. People need this kind of representation. We don't consider that the class is particularly vulnerable, but we're not aware of alternative forms of advice or assistance being available, which would make the provision of legal aid less likely to be justified. Nor do we consider there are alternative sources of funding. On balance, we propose to keep it, given the importance of our reciprocal legal obligations and the potential inability of litigants to bring proceedings without legal assistance. Objectively important because it's a universal legal aid situation for good reason. And there is one authority that will help us. If you see the footnote on that page, footnote 69, Council Directive.
Sorry, page again.
257.
Thanks.
Footnote 69, Council Directive 2002-8. Improves access to justice by establishing minimum common rules. Why do you do that? Because it's important and people need legal aid. But we've got an authority that deals with this area. You'll find it in volume 4 at tab 33, and that's in the electronic bundle at 4529.
Thank you.
And if I can just simply show you, please, paragraph 3 in the judgment of the Luxembourg Court. It's at the bottom of 4555. This is the directive improving access to justice by establishing minimum common rules.
Yes.
And you will be interested to see at the top of the next page, 4556, recital 5, the directive seeks to promote the application of legal aid in cross-border disputes for persons who lack sufficient resources, where aid is necessary to secure effective access to justice. So the idea that these are not need examples, we say, is impossible. It wasn't advanced below for good reason. The scheme of this schedule is, we say, very clear.
Yep.
Now, I keep saying I want to show you another case about regulations under Section 12, and I can't wait any longer. So can I ask you, please, to look at the Rights of Women case in Volume 8 at tab 75.
Yes.
It's bundle page 6015. Just to tell you what you're about to see. When you make non-Henry VIII delegated legislation under Section 12, and you're the Lord Chancellor, you have to decide what evidential requirements are needed of people who apply for legal aid. If you were to impose a requirement under Section 12 regulations that was not a function of need, then the argument would arise, a Padfield argument. Yes, you've got a Section 12 power of delegated legislation, but it's got to be exercised in accordance with the object and purpose of the statute. The relevant object and purpose is actually Schedule 1, scope. It's actually quite a good illustration of where we would be if it were being said you could rely on Section 11. It's exactly the same. You can't impose new criteria that cut across or frustrate the clear object and purpose of Schedule 1. But the answer, of course, would be from Mr. Eadie, well, you've got the object and purpose wrong. The object and purpose is not need, and you could do it if it saves money, because this is all with a view to public money. Now, that's what the Court of Appeal had in the Rights of Women case at page 6015. You'll see at paragraph 24, if we go straight to the heart of it, that they set out, it's a judgment of Lord Justice Longmore.
Yep.
Bottom of 6019, to remind you what you saw, you've seen Section 12, it's the enabling power for making regulations. We then get the impugned regulation on page 6021, paragraph 27. And what the Lord Chancellor has done in making these subordinate legislation provisions is to introduce a 24-month cut-off period. If you are a victim of domestic violence, but it happened 25 months ago, you're out. 23 months ago, you're in.
Yeah, we can see that, yep.
Argument that frustrates the purpose. What's the purpose? The purpose of Schedule 1. Where do we find it? 6027, paragraph 37. You find it in the judgment of the Divisional Court in Public Law Project and the judgment of the Court of Appeal in Public Law Project. So I've read you paragraph 37 of Lord Justice Moses, that's the analysis, there's no other feature. It's done by reference to need. We then, they make the point that it's not disapproved by the Court of Appeal, that is correct. At 38, on the contrary.
Misses out the sentence you object to, which follows.
Sorry?
It misses out the sentence, it does stop before the sentence you object to. In the quotation. I'm not
yes, no, it does, but that's my point.
Yeah, I agree.
I say 9 judges have correctly recognised the relevant purpose and object.
Yes,
it's just that our Court of Appeal has said you can change it.
Yeah, I understand. Point in your favour.
So you see the point, it succeeds. The court says it reflects the witness evidence at 39. We know it does in our case as well, because that's what Miss Gibby says in her witness statement. That is the purpose. It's to reflect need. Then we've got it's for the court, end of paragraph 40, to ascertain the purpose of the statute. Spath Holmes, we've seen. Drawing the threads together, partly to withdraw legal services from certain categories of cases in order to save money, but also to make such services available, perhaps not to the entire membership of most deserving categories, such as victims of domestic violence, but at any rate to the great majority of persons in the most deserving categories, catered for partly by needs requirements, financial needs, means testing, and merit, but also catered for by requirements the Lord Chancellor is entitled to impose. The question is whether they are rationally connected with that purpose. And then we get the discretion conferred should be used to promote the policy and object of the statute, line 4 and 5, could almost be a footnote in Bennion. Looking for a connection to the legislation's purpose at the end of 42. Is there one? No. Paragraph 44 and 45 and 47. Can I convincingly show that the relevant object and purpose is priority need, brackets with a view to save money? I say yes, and I say I've got 9 judges that agree with that. And the fact that it's with a view to save money doesn't change it. You can't strip out prioritisation of need and introduce something else. any more than you could distinguish between the 25 months and the 23 months. You can't distinguish between the non-resident and the resident, or regular resident and irregular resident, in exactly the same position in every other respect.
Yep.
I've covered a lot of what I was about to say next, so I'm not going to waste your time. Right, now I'm going to get to a privilege question, because I want the court to be aware of something that a parliamentary committee has said. And I'll explain to you what it is. I don't need it, but I do want you to have it. I'll tell you where we're going. It's a point that's it's in the materials.
Don't need it, that's a short answer.
Well,
Have with your cake and eat it.
Yes.
let me show you, first of all, the draft order itself that contains the new residence test. And you'll find that in volume 2E at page 2608. 2608. You know about the design of the residence test because you've seen it summarised in the statement of facts in issue.
Sorry, 2608.
Yes, 2608 is a draft. This was a draft statutory instrument that was laid before Parliament, in between the hearing in the divisional court and the judgment.
Is this in one of the appendices?
Yeah, 2E.
Sorry?
2E.
2E.
I'm so sorry. Did I give the wrong?
2E, no, you did. Correct.
I'm just getting...
2E 2608.
I see somebody else has been focusing on the point we were focusing on.
Oh, that's always good. My lords, my lady, then see an explanatory memorandum at 2617. I have 2 points, one benign.
Is this a duplicate of 2659? 2569?
2526 as well.
Because 2569 is, I think, quoted in your printed case as where the document is. Doesn't matter, I just don't want to read the same thing 3 times over.
All I did was make sure I'd located the one we used below as the one that had actually been put. I am not saying that there are changes in the text, but if you've marked it up elsewhere, then please look elsewhere.
It's always nice to have the same document
This is-
several times.
You ought to use the one at 2608. The one at 2569 is a draft.
Yeah, I thought I got
It's an
that.
earlier draft. So that,
I'm really sorry, because what we've done is we've cited the wrong one in the statement of facts and issues. I'm sorry about
I think
that.
Mr. Eadie is right. We ought to be working from
So
the same one. and B,
relieved
the
to
right
know
one.
there is that much common ground that we're on the right page when it comes to the explanatory memorandum.
Okay,
And my
we're on the
lords, my
same
ladies,
page to that extent. Okay, very well.
I just want you to see, first of all, 2618, policy background 7.1, final sentence on 7.1.
Yes.
Unless it's targeted at persons in cases where funding is most needed, it won't command public confidence. So I said that always the link between public confidence and targeting greatest need.
Yes.
We ignore the manuscript edition at 2608, I take it.
At 2608,
Yeah. Yes. Lord Mance has commented on already.
well, it's not in mine, so I'd have to see it.
Don't worry.
Get it.
Don't worry.
See, I'm so faithful to using the one we used in the court below that I haven't got Mr. Jaffe's very helpful manuscript handwriting. That should be ignored. That is not an admissible aid to a question of statutory interpretation, but I'm delighted that version was put before you.
So we can't take it into account, but you're
No,
right.
you can't,
Very
but
well.
I rely on it.
Okay. Yep.
So we were looking, I want to show you 2617. Because 2617 in the explanatory memorandum tells you that this is a matter of special interest for the Joint Committee on Statutory Instruments. What happened was the Joint Committee on Human Rights has said you shouldn't be doing this by primary legislation. But within the parliamentary process, it's the Joint Committee on Statutory Instruments that looks at such issues. Now, let me say immediately,
This is all after the why is this admissible to construing something that happened before?
it's admissible because, or relevant for you to know, because within the parliamentary process, the vires of the residence test has been red flagged by the relevant committee.
In connection with a draft statutory instrument introduced after the present one.
Correct.
Is that really?
My submission, Mr. Eadie.
Yes, it was introduced after the divisional court's decision, right?
Yes, it was.
Yes.
Well,
how can
what's
that-
surprising about it being red flagged anyway? I mean, it's certainly arguable.
But I just don't. We seem to be getting into potential, according to some people, Article 9 territory for a purpose which I'm struggling.
All right. Well,
Doesn't advance your argument at all, does it?
it doesn't, but it should temper the enthusiasm for accepting Mr. Eadie's argument that there is an affirmative resolution procedure. Lord Justice Laws didn't think much of it either. And because there is a parliamentary procedure, that indicates it's a wide power. There is a parliamentary procedure.
Why does whatever the Joint Committee may have said have any bearing on that at all?
On the fact that there's a parliamentary process.
Yes.
Because the parliamentary process raises the variates issue before a committee who red flags it as dubious.
I see.
But they're not the people who give an affirmative resolution or decide not to.
No.
And
Nor are they the people who ultimately decide on the lawfulness.
I'm not inviting you to determine this case on the basis that they are correct.
So what are you asking us to do?
I'm asking you to note the fact that within the parliamentary process, the doubtful variance of this has been red flagged. That's the submission.
we should refuse to take it.
Well, let's move on, and after the short adjournment, we'll have discussed whether we should.
Yes, thank you, my lords. I don't think in those circumstances I need to go further in relation to that. I've dealt with composite purpose and cost benefit. That's it on virus.
Well, what about section 41(2)(b)?
Or not to be.
41
Yes.
2E.
No, B. I think is the provision relied on.
Yeah.
Yes.
By Mr. Eadie.
40. I accept, as I have to, that the Section 9 power to amend Schedule 1 allows you to vary or omit or add services by differentiating.
According to characteristics of recipient.
No, by reference to class of individual.
Well, all right, class of individual.
First point, 2 points. First point, that is not a Henry VIII power, it's an incidental power that relates to all regulation-making powers within this statute.
Including Henry VIII.
Including Henry VIII.
Yep.
Therefore, if I'm right, if I'm wrong about object and purpose and you can't expand them with a Henry VIII clause, I'm going to lose. But if I'm right about that, this cannot carry Mr. Eadie any further forward. Because the power, and it includes making class-based changes, and I've shown you several examples of them on the face of Schedule 1, where you introduce on the basis of class, they are relevant classes like relevant services. And they are classes which are relevant to the priority need. So the victims of domestic violence, the family member at the inquest, children, those aged under 24. Would it allow you to introduce a class that has no reference to need? People who live in the south. Boys. No, it wouldn't. It does, it's a differentiation power, but only differentiation that matches the statutory objective.
No reference to importance, need or means. That's essentially what you're saying.
Yeah. Second point is that there's no sticking out like a sore thumb in the word class of individual, and that is because both in the design of Schedule 1 and, for that matter, the redesign of Schedule 1, we saw that the statute is replete with those examples where you can see relevant classes of individuals, just as you can see relevant proceedings before a particular court.
Your point about victims of domestic violence as opposed to alleged perpetrators.
Yes.
Yes, okay.
And we saw all of those examples. So it can't, and Lord Justice Moses is right, it can't expand the Section 9 power beyond what the Henry VIII power could already achieve. But what I do accept is you read 9 and 41 together. Of course I accept that. But take areas, 41(1)(b).
Yep.
Is the submission going to be that you could take people in a different geographical area where the need is exactly the same, but you could distinguish between them because of expense, save public money because there's a lot of tribunal cases coming from London, so no legal aid for Londoners in tribunal cases because we're allowed to save money and we're allowed to differentiate on the basis of area. Now, if you had free legal advice in every immigration detention centre, you might say no legal aid for those who are detained in these facilities. Why? Because it's not needed, because we're making other provision to ensure they get legal help. If you had free legal advice as a pilot scheme in a few immigration detention centres, or only the English ones and not in Wales, you could distinguish. It's relevant to need.
Is that a convenient moment?
Yes, and that, I hope, subject to questions I find I haven't dealt with, will be the end of Vares, and I want to do principle of legality next.
Thank you very much. We'll resume again at 2 o'clock. Court's now adjourned.